Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Clint Brannon, and today I'll be joined by my colleague, Tom Bergert, a partner in our IP practice group at Williams Mullen, to discuss artificial intelligence patents and emerging regulatory laws.
Tom, AI has been around for quite a while, and we've had patents related to AI for many years now. But AI has been getting a lot of press, even in the popular press lately, and has been generating a lot of public awareness. We've all been experimenting with ChatGPT and other generative AI programs now, and they're fun and helpful, and maybe we'll be able to use them, lessen our workload moving forward. But what are some examples of AI regulations that are in the works or coming down the pipeline that may have an impact on how people are seeking to patent AI inventions?
Yeah, hi, Clint. It's good to be here. And I think the AI regulations seem to be emerging, and there are some AI regulations that have passed at the state level. Some are under consideration at the state and federal level. And some examples would be in Tennessee, just recently, the Elvis Act passed, and it's tied to expanding the protection of personal rights to include sound and voice. So if you think of Tennessee, one thing that comes to mind, home of the Nashville music industry. And this act is intended to expand personal rights to protect, for example, voice cloning and voice mimicking. Think about a musician trying to record music, and he or she has his or her voice recorded and mimicked and cloned, and the AI software can make it sound exactly spot on for that artist. As an artist would want to have control over the use of that. Don't want to miss out on the commercial opportunities of your voice. That's your talent. That's your unique ability. And so this Tennessee Act, which was passed in March, I think it's going into effect later this year, 2024, is aimed at that, the use of AI for voice mimicking and cloning. Other states have similar legislation in consideration. In other areas of AI regulation, we're seeing some examples related to using AI to make automated employment decisions. I believe Maryland and Illinois have enacted laws in this area. Again, other states are considering legislation, and there's still other regulations that are out there related to giving citizens what's called an AI Bill of Rights. And Oklahoma is one of the examples that's talked about frequently in the current literature and research. And the legislators are considering the legislation that lets the residents know when they are interacting with AI software as opposed to a human, being able to opt out of having their data used to inform the AI for training purposes, for example, giving the citizens the right to approve the use of their likeness in AI-generated content and similar provisions. So these are just some examples. It seems to be very early days, and who knows, 3 years, 5 years, what we're going to be looking at in terms of the regulations.
Well, yeah, there's a lot of regulations out there, Tom, as you indicated, and many of these affect IP and other areas. Some could be copyright, publicity rights, but today we're going to talk about patents specifically. So how do you see AI regulations affecting how one might try to protect AI-related inventions going forward?
I think an easy way to think about it is it's another factor. All right, I've got issues all the time with prior art as a patent applicant. What's out there that will be used or could be used by an examiner in examining the patentability of my invention. In software-related patent applications, there's the concern of subject matter eligibility. That's something that can be discussed in separate podcasts at length. But now we've got another factor, and that is legality. And if AI regulations pass that make your invention or potentially just one use of your invention illegal, you can carry that out and say, well, is this something that's worth trying to patent? Is it going to be a commercial market for either licensing or selling my patent rights or asserting my patent rights? I think that's one of the things to think about. It's another factor. Timing is something else to think about. Okay, AI regulations, they may be coming out in piecemeal fashion. Certain states may prohibit something. Some states may be thinking about prohibiting something, and there may be a federal law. There may be international laws. So depending upon the jurisdictions where you may be interested in seeking patent protection, you may be affected by AI regulations that haven't even passed or may not even be under consideration yet. So with patents being, at least we'll talk in US terms, 20 years from your filing date, that's how long you can protect your invention through patent. That's a long time, and regulations could come up in the interim that affect the value of that patent.
That's really interesting, Tom, and that there's a few issues there that seem potentially things that people would want to talk about. You might have certain claims and the scope of the claims where they cover both legal uses of AI technology and some that might kind of go into the realm of areas that are forbidden by regulatory frameworks or laws. You might be able to have a voice cloning AI application, and if you use it for your own voice to generate content just to save yourself time for a podcast, for instance, or to prepare recordings, that seems like that would be perfectly fine. But then if you're using a celebrity's voice and cloning that, you would run into some of these other issues. Could you speak about that particular problem for a moment?
Yeah, and you hit on a great example, because voice cloning, let's take that example. If you are using this, you've got too much going on in your day, you're scheduled to record podcasts like this one, as long as you're reviewing that script and you're okay with the voice cloning software that clones your voice for the podcast, that might be something you'd be very interested in. It saves you some time. And so it gets back to the claims of a patent application or the issued patent. You may have uses of a claimed system or method that, if infringed by someone violating the law, well, there may be no or few candidates to assert those rights against. Whereas if you're using that claim in a way that's for a permitted use, it's legal, then there would be candidates for infringement. So it's something to think about as you frame your claims, and your claims may be something that's purely dedicated to something that's legal today, maybe something that's dedicated to something that may be legal, may be illegal. I think at the outset, you do your best job and you think about the ways that the law may come into play. And we've got hints from the past. The internet's been around for a while. We've seen privacy regulations, but this goes into, in my opinion, the prep that you do in thinking about how you're claiming your invention and trying to cover the ways that you think will be most commercially valuable.
Yeah, those sound like important takeaways, Tom. Yeah, I guess we should think about how we're claiming our invention. How are you going to adapt your application as things change, maybe continuation applications or additional applications moving forward, and forecasting regulations and sort of how you think the law is going to develop. Kind of taking all this into account, what sort of tools and information and resources are available to help people who are trying to approach patenting AI inventions?
Well, one thing that's always available, and not all applicants or inventors think about it or use it. If they're aware of it, they may not want to, but there are prior art searching approaches. You can do your own quick and dirty searching. You can use formal patent searches to evaluate and inform your patent application drafting. So there's prior art. There are also legislative resources online where you can see what's being enacted, what's being considered for enactment. Is it federal? Is it international? Is it state specific? There could be legislation, take marijuana as an example, where there, in some cases it's useful and legal for medical purposes, but it's not legal for recreational purposes. We could have a wide ranging scope of areas where your patent uses of that may or may not be legal, but only in certain territories. So there are legislative resources, there are prior art resources, and of course there are patent professionals like you and me helping our clients think through areas that they may want to consider for patent protection and how to claim those areas. There's no crystal ball. I think those that can see 5 years into the future versus 2 months or 3 months have an advantage. And I don't know anybody that can do that predictably every time, but if you're thinking downstream, if you're thinking about the term of your patent and how to maximize its commercial value, it seems logical to be thinking about legislation and how that might affect the viability of your patent application and the commercial value.
That'll wrap up our discussion of AI patents and emerging regulatory laws. I'd like to thank Tom Bergert for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thank you for listening.